What's going on, y'all? So I just received a decision in order in the mail today, and this is from Mellisa B. Deberry, and y'all familiar with this case, Queens Wellness Medical Care. She finally gave her decision after our complaint to the Commission on Judicial Conduct. Now let's get into this decision. First and foremost, this should say a decision after inquest, not a decision in order. This was a decision after an inquest hearing was held. It shouldn't they say decision in order. Secondly, it's not stamped, so it can't be enforced. Now, when you compare this decision in order to her decision in order on November 26th, which right here, she granted me the right to move forward on an inquest. You feel what I'm saying? You see that it's stamped, but then her decision after inquest, which it should state here, is no stamp, so it can't even be enforced. Now let's get into her decision. And this video, and this short is going to go past 3 minutes. So go to the video and see the entire thing, because it's a lot of bullshit that I got to point out. So right here it says, and I'm only reading the underline in the highlighted green section. The court advised plaintiff that although it was proceeding with an inquest, defendant would most likely be making a motion to vacate under CPLR 2101F. So right here, she's clearly admitting that she told me that she advised me that the defendant is going to try to vacate her decision right here, giving me the right to move forward on an inquest. She's saying that he's going to file a motion to vacate it under CPLR 2101F. Now, we know 2101F only deals with a defect in the form of papers, and that has nothing to do with my case whatsoever, let alone being able to vacate a decision in order granting me an inquest hearing. This law is not used for that. She's not mentioning that though. She's putting in her decision like it's all good, like it's valid. You see that, right? Next, it says plaintiff stated that what happened was medical malpractice. It was medical malpractice. If y'all listen to the hearing, because it was uploaded, you would hear me mentioning that the doctor refused to provide me with a referral. Now, what it says right here, a primary care doctor's refusal to provide a needed referral can be considered medical malpractice. So, yeah, it was medical malpractice. Okay, what's your point? Let's move on. Next page. It says he was referred for MRI, which was performed January 8th, 2025, and according to plaintiff, its findings demonstrated that his condition had worsened. Now, based off of my findings, it's based off of the doctor's findings. Now, let's look at here's the MRI exam that she's referring to. And here's the findings right here. But the doctor's report, this is the doctor who did the MRI is not the doctor who wrote the referral. So the doctor that wrote the referral, he made a report on this right here. This is enough, but the average person can't read this. A doctor know how to read this. But this shows that my condition got worse. But the doctor that referred me here wrote up a report stating in plain English that my condition got worse. And look, comparing Mr. Taylor's prior MRI lumbar spine done on 3/9/24 to his most recent, done on 1/9/2025, there's a new explicit compression of the right. You see all of that. Then it says, based on these worsening MRI findings in correlation with Mr. Taylor's worsening symptoms, Mr. Taylor continues to require medical treatment. Bong. That was enough right there. So, it's not about my findings. You see how she's trying to get slick? She's trying to say, according to plaintiff's findings. No, I handed those reports up to you at the inquest hearing. You got both of them. You feel what I'm saying? And she's trying to act like that wasn't handed up as evidence. But if you listen to the hearing, because it's uploaded, you're going to hear me handing up these documents. And right here, she's trying to act like she never received them. All right, next. Plaintiff complaint alleges willful misconduct and discrimination, not medical malpractice. Well, we don't need to read that. So then right here, she's breaking down CPLR 2101. But nowhere, as she breaking this law down, she's not mentioning that the defendant misapplied this law right here. And this has nothing to do with my case, and I broke this down already. A defect in the form of papers has nothing to do with my case. It has nothing to do with vacating her decision. You see? Next page. Right here it says, plaintiff asserted in no uncertain terms that this was a case of medical malpractice. Basically, she's saying everything that I stated at the hearing amounts to medical malpractice. I know it do. So why are you trying to force me to file an amended complaint? And it said, in the court find based upon the claims, plaintiff should be afforded leave to file and serve an amended complaint to assert an additional cause of action against defendant upon the grounds of medical malpractice within 30 days of the date of this order. So she's trying to act like she's doing me a favor by affording me leave to file and serve an amended complaint. But this is all a tactic. You feel what I'm saying? And this is why she's saying the inquest hearing is moot. Because I'm going to file an amended complaint. So that's what she used in order to render the inquest hearing moot that took place. And she's going to mention that on the next page. Oh, and down here it says, the court is cognizant, however you pronounce, that the defendant has filed a separate motion under motion sequence 3, seeking to renew and re-argue motion sequence 2, the decision of the undersigned dated November 26, 2025. So we already know he filed a motion to renew and re-argue this decision right here. Right? But we also know that you're not entitled to renew and re-argue the judge's decision granting me an inquest hearing. You only can renew and re-argue a decision on a motion that was filed by you. You only can renew and re-argue that. And I showed y'all the law that governs that. And right here, she's not, you feel what I'm saying? She's not saying that the defendant is not entitled to renew and re-argue. She's just leaving it as it is, as if he is entitled to it. You see the games? So this is complete bias and unethical. And she's working in favor of the defendant. Moving forward. So it says down here, order. The plaintiff is granted leave to file and serve a supplemental summons and amended complaint, a certain additional cause of action against the defendant within 30 days entry of this order. Next page. And this is all a tactic, y'all. So next page, last page, it says order that the inquest is denied as it is now moot, since plaintiff will be filing an amended summons and amended complaint to add an additional cause of action for medical malpractice, which supersedes the original summons and complaint. So you know that I'm going to be filing an amended summons and amended complaint. You just know I'm going to do that. And you see, this is what she's using to render my inquest hearing denied as it is moot. You see the games? And then down here it says, well, we're going to read the one that's not highlighted here. It says, ordered that upon defendant filing of his answer to the amended complaint, the clerk is directed to place the matter back on Part 11 calendar for a pretrial conference. See? So all of this was done to deny my inquest hearing, my decision after inquest, to deny it, saying it's moot, and to also put this case back where I started out at. You feel what I'm saying? And she was trying that from the very beginning. And now she's doing it, she's not trying it, she actually did it. So you can see where the wrongdoing is at here. And it will be a complaint against her. And then the last thing it says, ordered that if plaintiff decides not to file and serve a supplemental summons and amended complaint as directed herein, the matter shall be placed back on the Part 11 calendar for all purposes, and the parties shall be notified. So whether I file a complaint or not, she's still gonna send the case back down to room 101, part 11, where I started out at. You see that? Now, how are you gonna render my inquest hearing? How are you gonna deny it as it is moot, since plaintiff will be filing an amended summons and amended complaint? I won't be filing that, and you're still gonna render it. You're still gonna deny it and say it's moot. This don't even make no sense. You feel what I'm saying? Once again, it's being denied and it's moot because now I will be filing a summons and amended complaint. But I'm not obligated to do that. And I actually don't have to do that. Because when you look at my complaint, my original complaint, well, my only complaint, it's for intentional misconduct and discrimination. Where's this medical malpractice is a part of this, though? You see? Intentional misconduct and discrimination. And when I argued the case, I proved that it was medical malpractice. You feel what I'm saying? So I don't have to file no amended complaint. And if you want, you could leave medical malpractice out, because I didn't put it down here. You see? But here's the games that's being played. Just look into if the case is intentional misconduct and discrimination. Just look into that. You feel what I'm saying? Just look into that. You know, so it's a bunch of games that's being played, y'all. And yeah, that's about it, man. There will be a complaint. I'm trying to see if I forgot anything. It will be a complaint for this, because I could clearly see the tactics that's being done. I'm gonna holler, y'all.